Garcia versus State.
Good morning. The defendant in this matter was accused of engaging in illegal sexual activity with CS, a friend of his niece, AM, during an overnight sleepover at his residence. At the appellant's trial, the state's evidence relied primarily on three sources. The first was a William Jewell witness, Teresa Cole, a controlled call that occurred approximately 2 months later between the appellant and CS, where the defendant never explicitly admitted to the charged offense, and the victim, CS. I'd like to first address the fact that in all of these three sources of evidence, reversible error affects all three sources. Specifically, as to the Williams rule evidence, the court erred in allowing Ms. Cole to testify at the defendant's trial. An application of the McLain factors clearly indicates that this was prejudicial more than it was probative pursuant to the statute. The only similarities that can be adduced from the two charged offenses were that they were pubescent women, sexual intercourse occurred, and that they knew the defendant. However, the dissimilarities are much more expansive. For instance, Ms. Cole had known the appellant since infancy. The CS had only known the appellant for approximately a year, and their contact was very, very minimal prior to the alleged sexual activity. In Mrs. Cole's instance, he had babysat for her, in fact was friends with the family, and only at approximately the age of 13 did he take a special interest in her, according to the testimony. In CS, the case at hand, he had never taken any interest in her. The only occasion he'd spent time with her was one sole ride back from school. He dropped her off at her house, and that was it. More important, the special interest that was taken with Ms. Cole indicated an evolution of sexual activity. It started off with a kiss, oral, then actually vaginal intercourse. In the case involving CS, which is the case at trial, there was no escalation, there was no evolution. It was essentially one night where there was an intensive use of alcohol, and it ended up with sexual intercourse, according to the testimony. There was no evolution, there was no time period in lag. Also, Ms.
There was alcohol with the Williams rule evidence, although alcohol was not part of the sexual encounters, is that right?
Correct. Alcohol came later. It was never utilized as a method to facilitate the sexual activity. With CS, the victim in the case, alcohol was intensively used, 5 drinks according to the victim, during that evening to try to, to facilitate the sexual activity. In Ms. Cole, she indicated the alcohol came after the sexual activity. It was a long-term relationship. He would take Ms. Cole, according to the testimony, to theme parks through Central Florida. With the victim in the case, he did not do that at any point. It was just one night versus a whole relationship. And the important factor is that relationship, one of the things is the intervening act is one of the factors in McLain. There was an intervening act with Ms. Cole. The parents, when she approximately reached the age of 16, entered a restraining order against the defendant not to allow him to come by her. With Ms. Cole, with the victim in the case, there was no intervening act. In fact, after the allegation of sexual activity which occurred in June, the defendant made no attempts, nor did she, that being the victim, make any attempts to communicate with the defendant or otherwise. There was no attempt, there was no intervening act because there was never an attempt to continue that alleged relationship past that night. In Mrs. Cole's instance, there was a long-term relationship that continued throughout that period of time up until that restraining order. And again, these instances that are separated by approximately a decade of time. Now, what the court did in its order in entering and allowing Ms. Cole to testify, attempted to fashion restriction upon what type of testimony could come in regarding the relationship. But what she did, or what the court did, was that it said, we'll have that one instance in 1999 in the back of the vehicle come in. But that, in essence, is like attempting to take one scene of a movie picture and say it's just like every other picture because there's people acting in that. That takes away the whole context, the whole character, the location and the manner of the activity. It basically opens the doors, the McLain court said should not happen, to any sexual activity coming in any of these types of cases. So that's why the Strom case, I think, is instructive in this. In the Strom case, it dealt kind of the opposite, the mirror image of what we have here, where it was a long-term relationship that the individual was being charged with, and the Williams rule evidence was of a one-time event. The court says the character of those two are different. You cannot have that. That does not pass the McLain test. Here we have the same situation, but on the mirror side of it. We had a situation where, in essence, there was they isolated one instance in a completely different type of relationship, over 10 years old, and admitted it in this case, and all it did was prejudice the defendant under 403 by showing there's a propensity to commit these types of activities. That deprived Mr. Garcia of his right to a fair trial. And that's why, for that matter, it should be reversed for a new trial. As to the second matter I'd like to address, has to do with the state attorney's comments during closing argument. And I think the statement is very important. The state attorney during closing argument stated this: the defendant doesn't try to get out in front of the situation, doesn't go to the sheriff's office, doesn't go. Objection, and a motion for mistrial was made. This has to do in the context of the control call that happened 2 months later, wherein in the control call, the defendant was telling the Ms. CS to deny everything. There was never an explicit admission. Okay? Now the state is trying to say you need to listen carefully to his comments and what he is saying on this control call, because he didn't get out in front of this. He didn't go to the sheriff's office and say, hey, look, I didn't do this. That is a classic comment on his pre-arrest silence. At that time, the state is essentially saying, you now didn't go to the sheriff's office and proclaim your innocence at that point.
Why isn't it a fair comment on the testimony that came out?
Well, the testimony never...
He didn't deny it. He's characterizing the controlled call. The guy is setting up a situation where the victim will deny everything.
Well, I think the context was not so much a fair comment, because I think what the defendant was saying in the control call, and again, this is all subject to interpretation, is deny everything that they're accusing me of doing. Now, in that, I don't see how it's a fair comment if he's directing her to deny, okay, for him now to go to the sheriff's office and deny.
So you would parse that and say it might have been fair comment for the prosecutor to discuss what he's telling her.
Correct.
But not discuss what he didn't do.
Correct. Because he can comment and say, oh, well, he asked you to do that. That obviously is an indication of guilt. I think that's a fair comment on that point. But for him to say, well, he needed to take a step further. If he truly was innocent and essentially shifting the burden, he should have gone to the sheriff's office and said, hi, I'm innocent, I didn't do this, I'm denying everything. That is a comment on his pre-arrest silence.
Well, isn't though, I mean, to tell you the truth, I've read this statement a lot because you featured it in your brief. It seems like a nebulous comment to me. And to tell you the truth, I would imagine that most of the jurors didn't know what he meant by it, and it never became a feature of the trial. And as a matter of fact, the state themselves sort of moved off it in their closing arguments when they basically reminded the jury that the defendant doesn't have to prove anything, the burden's on the state, the defendant doesn't have to get out in front of anything, whatever that means, whatever that means. So if there's an error here, It's kind of below even harmless. It's a maybe error that maybe the jurors understood, maybe they didn't, never became a feature of the trial, and was more or less retracted by the state themselves.
Well, I think, again, an issue of, once the error is established, obviously the state would have to establish beyond a reasonable doubt that it was not reversible. And I think here, it's very hard to get into the minds of jurors. But one thing we can look at is the action of the jurors in this case, is that when the state focused on that control call, the juror heeded the state attorney's argument, and they asked to rehear that control call again. And at which point, shortly thereafter, they rendered a verdict of guilty. So obviously, the control call was an important aspect of the jury's deliberation. Thus, any activity or any actions the defendant did or did not do in response to that control call, I think are significant, and I think they would be reversible error, due to the fact that the whole issue here was the comments by the state in the context of their closing argument, that he was essentially, by asking her to deny everything, was telling her, listen, I'm guilty, deny everything that they're asking me, because that's why I'm not going to get into trouble. For not to go to the next step and say, well, if he really was innocent of these charges, which he doesn't have to prove his innocence, but if he was not guilty of these charges, he should have gone to the sheriff's office. I don't believe it's nebulous when he says the defendant doesn't try to get out in front of the situation, doesn't go to the sheriff's office. Placing upon the defendant an affirmative duty to essentially establish his innocence, which is clearly the jury instructions say that it must be the state's burden and responsibility. Anytime the state places an affirmative duty on the defendant to prove or disprove any aspect of the case, I think that would be reversible.
Well, the difficulty with your argument, though, is that you have now read a huge amount into this nebulous statement, just by virtue of what you've just told us. You have sort of anticipated what you think might have been meant by this extremely nebulous statement.
Well,
and I would suggest to you that there are others that would hear that statement and have a totally different view of it.
I think one thing that can be said, without being nebulous, is that it does create an affirmative duty on the defendant, in the sense the state specifically says doesn't get out in front of the situation, doesn't go to the sheriff's office. That, I don't believe there's nothing nebulous about requiring the defendant, the state requiring the defendant to go to the sheriff's office. Now, as to what can be interpreted
in terms of where this was in the timeline, at that point, he did not know that there even was a law enforcement investigation.
That is correct. And so at that point,
your argument is, the suggestion is that if he was innocent, he should have gone to the authorities and said he was innocent.
Correct. That is clear. There is a clear affirmative, the state's placing an affirmative duty or response on the defendant to go to the sheriff's office to proclaim his innocence.
How does this fit in the context of a single comment made in a much longer closing argument, where the state then reminds the jury that the state bears the ultimate burden, the jury's instructed that they bear the ultimate burden? I'm trying to figure out, is this really as big as you're making it out to be?
Can the bell be unrung, and if there wasn't a large bell? I understand the court's question. I think the state attempted to unring the bell by trying to do that curative comment. However, its curative comment only went to one aspect. It went to the shifting of the burden. It never addressed the issue of a comment on his pre-arrest silence. So the curative comment was incomplete at that time, and it was not complete to cure the ringing of the bell. Now,
tell me, I think you said earlier you're sort of trying to connect that comment to the jury's subsequent request to hear the tape again. Tell me how that works. How can I read that into it?
No, I said you can't interpret what the jury's thinking. All I'm saying, you can look at the actions. The state, during its closing arguments, did focus much on the comments on the control call. And they made that a feature, the control call was made a feature of the state's closing argument. The jury heeded that, listened to it again, and then rendered a verdict. I can't say what they were focusing on. No one can. That would be impossible to say. But the control call was a feature of the state's closing argument. This was an aspect that the state was attempting to develop, that if he is proclaiming, telling this victim to proclaim his innocence, why did he do the same thing himself affirmatively in front of the sheriff's office and stop this from going any further?
Mr. Gomez, you're down to 5 minutes.
Thank you.
May it please the court, my name is Marilyn Becchio and I represent the state of Florida. With regard to issue 1, the appellant's argument is essentially that these two offenses were not sufficiently similar. And as this court knows, the legislature in passing 9404B2 kind of relaxed the standard for purposes of child molestation cases. But even under a traditional Williams rule analysis, the level of similarity between the prior offense and the charged offense depends on the purpose for which the state is introducing the evidence. So in instances where the state wants to prove the identity of an individual by using a prior bad act or prior offense, the level of similarity is relevant because it is the similar nature between the two acts that makes it probative in this case. That this individual committed a prior act in a very specific way, and therefore it is probative of the fact that they committed this act in the very same way.
In terms of the identity.
Yes, in terms of the identity.
What was the purpose for which this was?
This was corroboration. And again, 9404B2 recognizes that in these cases, even more so than other kinds of crimes, there are usually only two witnesses, the perpetrator and the victim. And the defense is usually the victim is lying, mistaken, whatever, those kinds of things, making it up for a reason other than the fact that the defendant is actually guilty. So the legislature recognized that these cases require some corroboration. And the corroboration here was that those two individuals, those two women, were about the same age. The sex acts were very similar. And the court in this case really took heed of its duty to be a gatekeeper in limiting the amount of prior bad act testimony that came out in this trial. It was a very short testimony by the victim. It did not become a feature of the trial. It was sufficiently similar. And even if you look at McLain, even if you look at McLain, the acts in that case are even more dissimilar than the acts in this case. So in McLain, we had a young boy who was around 8 or 9 years old. The victim in McLain was about 8 or 9 years old. And there was an accusation of digital penetration of his anus by the defendant. The Williams rule case in McLain, the victim, the abuse started around 10 or 12 and ended when he was 14 and exceeded far beyond digital penetration of the anus. And there were multiple acts by the defendant in that case against the Williams rule victim. And the trial court in that case limited the testimony to one instance of a prior bad act that was similar in nature to the one that was charged in McLain. And the Florida Supreme Court said it was sufficiently similar to be both relevant and probative. And if the court examines the record in this case, you will see that the trial court made a similar analysis and said it was sufficiently similar to be relevant and probative. And in the Strom case that the defendant relies on, excuse me, the issue there was different because we had an admission of multiple acts. The charged offense was multiple acts against, I think, his 6-year-old daughter on a daily basis of a certain kind of sex act. The prior bad act testimony in that case was essentially a rape of a 12-year-old girl who was a complete stranger to the defendant in that case, and it happened about 20 years before. And the court found that those were too dissimilar to be relevant and probative. In this case, we don't have that kind of dissimilarity.
Well, you know, in a way, limiting and I think Mr. Gomez touched on this, limiting the admissible testimony, admitted testimony to the one instance, kind of, wouldn't that have been a little misleading to the jury in terms of one of the major differences between these two situations, which is one is sort of a long-term, almost familial relationship, and the other is, you know, in the charge in this case is just a one-off.
And I think
with someone that, you know, basically didn't really know.
Right. My recollection of the victim, the William Rule
The
testimony,
Williams rule.
thank you, was that she did go into the fact that she had known the appellant, that there
But
was a
she was
familial.
not allowed to go into the fact that this was a sort of an extended sexual
Correct.
relationship.
Correct.
And then, of course, then looking at the act that was admitted, you know, you're talking about in the back of the car, off in some woods or wherever it was, versus, you know, in the home, in the bed, you know, very different. So I'm trying to think in terms of what is being shown to the jury. Seems to me what the corroboration here is may just be propensity.
No, I think the corroboration is these girls were about the same age. They're pubescent girls, around 13 or 14 years old.
Well, that's why it's the crime that it is.
Well, yes, but I mean, there could be an instance where the victims are drastically different in age or different in gender, and that's not what we have here. We have the same gender, same age. There is a applying of sorts as far as alcohol was used in this case, and that there was some, escalation of the relationship.
There was use of alcohol in the relationship, but didn't she testify that it didn't have anything to do with the sex?
Yes, yeah.
Is that testimony given at trial or just in the Williams Rule?
Just in the Williams Rule evidence. And I'm not suggesting that the alcohol is a similar factor. It's just the nature of the plying of the victim in a way to cause them to have their guard down, to be compliant with what the defendant, in this case, what his intentions were, which was to sexually molest both these girls. And, you know, if the Williams Rule evidence came in and there was this whole series of events, I think we'd be here arguing that that was too much. So that's why the trial courts have some discretion.
Well, I understand that dilemma, but one of the major differences between these two relationships was basically two instances was essentially excluded from the trial, and the defendant is on the horns of a dilemma there too. You know, I mean, it's
right. But again, I think the burden on the appellant in this case is to show an abuse of the trial court's discretion, and the trial court used its discretion and did formulate an order that was considerate of the differences and the similarities between these two offenses. And I don't think the appellant has made a case for reversible error as far as that goes, because again, it did not become a feature of the trial, which is really a key in Williams Rule cases as well, that we don't want that prior evidence to become a feature of the trial. And this was very limited, and it did corroborate the victim's testimony that the appellant in this case committed the same kinds of sex acts against her.
If we were to determine, though, that this was not properly admitted, we don't have to find a feature of the trial, right? I mean, properly admitted Williams Rule becomes a problem if it is a feature of the trial.
Yes, Your Honor.
If it's not properly admitted, where are we?
Well, if it's not properly admitted, then we have to do a harmless error analysis.
So that burden goes to you.
Correct. And I think in that case, you still have to look at how much of the evidence came in, how much of the Williams Rule evidence came in, and whether or not you can find beyond a reasonable doubt that it did not affect the jury's verdict. And sure, in those cases, the state has the burden, and in Williams Rule cases, the burden is significantly more difficult because of the nature of the evidence, and the state doesn't, deny that in any respect. But I think that we have to remember too, 404B2 relaxes the standard in these specific types of cases. And there is a recognition that the victim's testimony oftentimes needs corroboration because they're the only other person who is in the room, in the car, in wherever that isolated place that the defendant takes them to commit these acts against them. They're the only other person there. And the defendant obviously doesn't have any burden to testify, which we'll get into in a minute. But I think the court in this case used discretion.
But that corroboration cannot be just simply propensity.
No. But these types of cases are different than a bank robbery, than an assault, than any other type of case, and that is why we have this specific rule for these specific types of cases. With regard to the state's comment and closing argument, I think there's an important thing that's missing in the discussion here. The objection was sustained. So there was an objection, it was sustained. The next thing was the motion for the mistrial. So the standard that we have to look at here is whether that comment actually vitiated the fairness of the trial such that there was a due process violation. So this isn't the kind of, if the objection wasn't sustained, we'd be having a different conversation about the effect of the statement on the jury. But the statement was very slight, and honestly, when I first read it, I wasn't quite sure what what the purpose of the statement was and where the prosecutor was going, because she didn't get a chance to get there because there was an objection and it was sustained. The prosecutor did then point out, obviously, that the defendant does not have the burden to prove anything. The jury was given that instruction, and as far as requesting the controlled call, I don't think we can speculate that they would not have or would have done that regardless of this statement. The controlled call was an important piece of evidence that the state presented. And, I would be speculating just as much as anybody else to say that they would have asked for that anyway, but I think that's probably a good guess because it was an important part of the state's case. And whether they could recollect everything that was said in that controlled call, probably not, and they probably would have asked for it anyway. So I think because we have a situation here where the objection was sustained, and the question really is, was the mistrial properly denied, the appellant cannot show that this vitiated the fairness of the entire trial. It was very brief, it was not mentioned again, and the jury was instructed more than once that the defendant doesn't have any burden at all. And if the court doesn't have any other questions, thank you.
I have no response.
Okay, good. Thank you both. We will now return to the first case on the docket, which is Cobb versus State. We're going to do a little housekeeping here. We're happy to have our new junior judge.
Yes.
Join us.